In this video, I want to discuss the issue of employer liability for sexual harassment complaints. This is regrettably complicated, and I'm speaking now only of Ontario. I got my crib sheet here. It's unusual in Ontario because the statute in Ontario, this is under the administrative process, under the Human Rights Act, Human Rights Code in Ontario. The statute creates employer liability basically for any kind of workplace human rights violation except a direct sexual harassment complaint. And why that is, I don't know. So there are exceptions to that, and I'll explain the exceptions, but let's just deal with the general rule first, that if there's a sexual harassment complaint, then the employer is not responsible. It's true. What can I tell you? So here are the exceptions. The first is that if the wrongdoer is the directing mind of the corporation, that is, if he, I'm using he, it could be obviously any gender, if that person is in charge of the company, principal, controlling shareholder, director, super boss, super poobah, whatever, then that person and the corporation can be held responsible. The second situation is where there's a poisoned work environment. So if the employer has allowed the standards of the workplace to fall below that which is reasonably expected in a normal expected workplace, I'm really mumbled that one, then the employer can be responsible under this concept of a poisoned work environment. I would expect, and the law is that one incident is probably not going to be enough to create a poisoned work environment. You'd have to show a history of failings over some time period to show the employer basically has let the workplace deteriorate to a standard that's not acceptable. Now, the third example is particularly complicated, and that is reprisal. Now, under the human rights legislation in Ontario, there are two types of reprisal. I'm going to use one term that I call general reprisal, which is not in the statute, not in the code. But the way that works is that if an individual files a complaint or threatens to file a complaint, and the employer takes adverse action against that person, such as termination, demotion, or whatever it may be, then the employer is responsible on what is called a general reprisal complaint. Again, I use the word general, it doesn't appear. Now, that's to be distinguished from something that I call a sexual reprisal. So if the boss says, hey, I'd like to get close to you tonight, let's go out for a date, and the employee says, I don't think so, and there's some adverse action taken due to that refusal, then that is a sexual reprisal. Again, those words don't appear in the code. Those are my words. And in that situation, the employer is not responsible. You have to show another exception to get in there, one of the two exceptions I mentioned above. So for that direct sexual reprisal, the individual is responsible, but not the employer. So under the human rights policy guidelines in Ontario, they say, well, don't sue people personally, please. That's not really what we're all about. Well, ignore that for sexual harassment complaints. For a sexual harassment complaint in Ontario under the statute, always sue the individual, and you're going to try to get some deep pockets. So what you're trying to show is the directing mind exception, or the poisoned work environment, or the general reprisal. And if you can establish that, then the employer will have liability. It's exceptional. It's the only jurisdiction that has this exception. I'll discuss the others momentarily, but that's the law in Ontario. And I also will discuss in the civil proceedings how the employer can be made responsible as well.